Hello, everyone. How are you doing? This is we're here live, bringing a show to you about the latest developments on DACA, and we have really good news for you about DACA. As you may already know, a federal court in Maryland ordered USCIS to basically follow the Supreme Court decision that Martin and I were talking about last time. The order is about DACA and making sure that USCIS accepts initial applications for DACA and also for advanced parole, which is the travel application. And this new order basically makes clear that DACA must be restored in its original state, again, which means it must accept new applications and travel applications. But as you know, the last month, the Supreme Court said that the Trump administration violated the law by ending DACA because they didn't consider certain important factors, which essentially puts DACA back into its original state, which how it existed before September 2017, before the DACA announcement was made to end it. Well, since the Supreme Court decision, we've been waiting for further instructions from USCIS, and this basically tells us, this new order basically tells us, or it gives us a little bit more confidence in filing the application. At least USCIS should accept it. Again, there's that word of caution that the agency has to usually makes an announcement about how they're going to treat certain applications if there's a change in law or a decision made by the Supreme Court. So we have been receiving your questions during this time, and Martin and I, we'll go ahead and cover those questions. And again, if you have any questions, feel free to ask those questions during our live show. We'll be happy to address those. The first question that we have that we received, let's see if we can get this on the screen. Oh, let's see here. I don't know if we can see that. Oh, little technical difficulty there.
Yeah, it's on the screen.
Okay, I see it now. I received DACA in 2014 and had it until 2018, but I didn't have money for the renewal. Am I eligible to apply after the court rulings? Martin, you want to take that?
Sure. Again, and thanks for the intro, Nick. And hello, everybody. We're just so happy again to be talking to you live. Nick is in Fort Worth in our actually at his home. We have an office in Fort Worth, and I'm in our Dallas office. It's been tremendous news for our clients, prospective clients, and really deserving individuals that were brought into the U.S. Not on their own volition, but they were brought in by parents or however way they were brought into the U.S. and then they just got stuck in the limbo. They grew up among ourselves, and they've been contributing to the society, and many of them, thousands, hundreds of thousands of them, were not able to fully participate, even though they would pay taxes, but they just could not advance any further. And so the Supreme Court last month just had an excellent ruling, and then last Friday the federal judge basically had issued an order that if the USCIS would not comply with putting DACA into the pre-September 5th, 2017, that the court would hold the USCIS in contempt. So they basically will have to start receiving new applications, so what we call initial applications, and it's just a fantastic news for everybody out there. We have been consulting with many clients and prospective clients, and so now it's time to start sending in these applications. So for those that did not have DACAs, we are going to be sending the initial ones, and for those that have had DACAs and they meet one of the three requirements for the travel document or advanced parole, we will be preparing those and sending those in to USCIS. So To answer this question, you would have been eligible for renewal even prior to these court rulings. It's basically prior to that, prior to these court rulings, anybody who had DACA and it's been less than a year since the expiration, they could have just submitted the application, the forms with the most recent approval and the copy of the work permit. And if it was more than a year, if the validity lapsed and has been more than a year, even prior to these two court rulings, you would have been eligible to renew. But the difference is that you would have had to submit all the original supporting documentation with physical presence, the fact that you entered the U.S. under the age of 16, that you are at least 15. That you were in the U.S. Physically present since June 15th of 2007 until the point of applying for the benefit for DACA, and that you had fairly clean criminal record, that you've graduated from high school or are in high school or obtained the GED of this kind of education, and that you were out of status on June 15th of to 2012. And so those are the requirements. If you meet them or met them even prior to these court rulings, you would have been eligible for DACA.
Yeah, and these are again, this is you're applying for DACA not only because there's a lapse in time that your DACA status has expired over a year, but now since we're talking about a new Supreme Court decision, this is if you're filing for DACA for the first time, that you have to meet these requirements. And you mentioned some requirements there, Martin, and also to add to that, if you were going to prepare your application for DACA, there is an age limit. You have to at least be, in general, you have to be at least 15 years of age to file your DACA application. Now, there are some exceptions for those who are currently in deportation proceedings, or if you have been deported in the past. And we highly recommend, if you fall in that category, if you've been deported in the past, you definitely want to seek legal representation to figure out what your options are. Again, a lot of these details, they still need to be fleshed out. There's a lot of unanswered questions regarding how they're going to treat certain applicants, but it's good to know the criteria. And on our Facebook, we should be sending, I don't know if we have it there yet, Martin, but we're going to be sending everyone the criteria for first-time applications.
And one of the things that I failed to mention, and which is an important requirement, and that is that you were born after June 15th of 1981. And so you basically had to be under the age of 31 on June 15th, 2012. So if you were born if you were born after June 15th of 81, then you are in the clear. You may apply for DACA.
Yeah. So that, and again, June 15th, 2012 is when the DACA announcement was made, and you have to show that you were under 31 years of age to file. Now, there's been discussions later on after that to get rid of the age limit and all that, but we have to wait and see what happens. There has been discussion in terms of legislation, DREAM Act and the American Dream and Promise Act, for example. Those are proposals, and we've seen that in those, or under those proposals, you see that they did away with the age limit. But again, just to emphasize, we're talking about DACA, which is a temporary solution. It's a temporary option. It's not the law, as opposed to something more permanent, like the DREAMer legislation that we've seen, that offers a permanent protection for those who meet the requirements. We did receive another question. Let's go through that. Let's see here. My DACA lapsed over a year. When I applied for DACA, when I applied for it, I was in high school, but I never finished my studies. Will I need to prove that I have graduated? And that's a good question that we often get, right, Martin? It's about the school and the educational requirements.
Yeah, we do. And again, typically, if it was less than a year, then the agency, the Immigration Service, did not really check or asked about it. But if it's been more than a year, then basically you're treated as if you are applying for initial application, and you are going to have to prove that you've graduated your study. So yes, that is something that you are going to have to prove. Now, under the current court orders, you know, the people often ask, well, would I have already had to have graduated? But given the fact that now we're under these two court orders, you're just going to have to show that you are enrolled in either you're in school or you're enrolled in GED, and you will satisfy that requirement.
Yeah, and it's different for those who are renewing it. With those who already have DACA and want to renew it, they don't have to show that they completed their schooling. They don't have to show that they actually, at the time when they apply for DACA, they may have been enrolled. For renewing purposes, you don't have to show that you finished it. It's a pretty straightforward process.
Yeah.
We have another question here. During the required physical presence period, we had to leave to Mexico, I believe in 2008, and we returned about a month later. Will I be able to apply for DACA?
So I presume that the person who sent us this question did not have DACA. So we're talking about original DACA. So I believe, so yes, basically, if you had left and returned fairly quickly, brief, casual, or innocent absence is basically the term. Generally speaking, it's something under 90 days. Then and you didn't leave as a result of being in removal proceedings and being ordered removed, or receiving a voluntary departure or some type of administrative voluntary departure, and if you left, it wasn't for any type of criminal activity, then you would be eligible to apply for DACA. We've had many clients with this fact pattern. And they obtained the grant of DACA, so they were approved.
Yeah, and what kind of documents? Now, since we're going to be focusing more on new filings, they're going to be asking the applicant the evidence that they've been here since 2007, and what type of documentation is immigration looking for, Martin?
Well, I call it anything, everything in a kitchen sink. So anything that you can collect, you can gather with your information on it. So if you are in school, basically your report card, your records from school attendance will do, medical records. If your mom had taken you to doctor's office. If you were older and you were renting an apartment, you would want to provide copies of your leases, and banking records. Literally anything and everything that you can gather. I remember we've had some cases where we were looking at social media accounts with posts and photos and being posted, showing that the person was right next to McDonald's in particular town, and so we use that. We try to use the date on the pictures, on the original, the 36 millimeter, whatever it's called,
Mm-hmm.
and the rolls of films when they're developed, so we've used that. But one thing I want to point out is that while you can kind of be a little loosey with the physical presence evidence for the between the 2007 and on, they want to see that you will physically present in the U.S. on April 15th of 2012, and so it's really difficult to show it with secondary evidence. We've seen some cases that there was a request for evidence where we've had a client submit an affidavit from a sworn affidavit from a friend or from a pastor or other people, and immigration just weren't buying into it. The agents, they wanted to see firm evidence, something tangible that the person was here on that date. But other than that, if you can find something within the, let's just say, 90-day period, it doesn't have to be every week, every month, but every other month, perhaps. We've had some bigger holes than 90 days, and it passed, but it just depends on luck of a draw of who's the officer and how they're going to regard it. But solid evidence for physical presence that you were in the U.S. on April 15th of 2012, and then evidence of June 15th, 2007 and onwards until the point of applying.
Yeah, if you don't have any evidence that indicates your name, you could also use evidence that you could ask your parents, or your parents might have some information as well on any evidence that indicates that you were here, such as tax returns. And if you were listed as a dependent, that could also help. Vaccinations, doctor visits, any documentation that shows that you were here, as Martin says. One interesting policy, though, one of the old policies when we had DACA, the original DACA, was that if you were missing evidence of your residence here, let's just say that you were missing at least 6 months to show that you were here in 2008, you couldn't just fill that in with a letter, right? A lot of people were writing letters and saying, yeah, this is a letter from my neighbor or from my employer that indicates that I was here. You have to show something in addition to that. Letters are fine, but you would also have to show something that is more
something
concrete.
Corroborating. Right, exactly.
Yeah. Here's another question that we received. And I currently have DACA work permit. Am I eligible for a travel permit? And that's a question that is raised after the Supreme Court decision. Is the old policies as DACA, when DACA was operating, the original DACA, they did allow for applicants to apply for a travel permit, and this is called advanced parole under certain requirements. Now, they did away with that when they were phasing out DACA. This was in September 2017, and they weren't allowing applicants who had DACA to apply for advanced parole anymore. But now, since things have opened up, we're going to be, and we have been receiving more questions from our clients regarding whether or not they can file their advanced parole. But what are some of the requirements for that, Martin? For the advanced parole?
It's you just can't just say, look, I'd like to travel, I want to, because a lot of DACA grantees are hearing, and they're on various groups on Facebook, and they basically just hear somebody getting it or having it before. They just want to just basically, now that it's open after the court ruling, they want to apply for one. So can you apply for one? Yes, but do you satisfy one of the three requirements? And so those are generally, well, you have three: humanitarian ground, then you have educational ground, and then you have employment ground. And so if you don't fall within one of those three, then you would be rejected. And so when people ask, well, what is humanitarian ground? So generally speaking, it's somebody very close to you who is abroad, is terminally ill, or there's a pretty big emergency, health emergency with them. Initially, everybody regarded it under the old DACA when applying for travel permits as a parent who was ill or who's dying or who died. And it somehow it extended towards or to grandparents, for example, or we've had cases of aunts and uncles that were basically the primary caretakers, and they were ill, and they were able to secure the travel permit. We've had clients that were students, and they were attending schools that part of their curriculum was study abroad or travel abroad, and so were successful in obtaining those travel permits. And then, of course, the third requirement, or the third ground, it was employment. And so if you are an employee at a company that requires you to travel on a business trip for negotiations or whatnot abroad, then you could apply as well. Again, you need supporting evidence for the business. You would need some type of a employment letter, a reason for travel, and then of course you need to fill out the form for the advanced parole, stating the reasons. If you're in school, again, evidence of the curriculum and some type of letter, perhaps from the registrars at the college or university. And for humanitarian purposes, it would be, you know, the basis for the travel. So if somebody died, then you'd have the death certificate. You wouldn't show the relationship, or if somebody's in the hospital, you want to get some type of a letter showing diagnosis, prognosis, and so then you can use that as support. We've even had some emergency travel for DACAs that you were able to apply at the local field office. So we are in Dallas, and so this is a Dallas field office where they would grant these emergency advanced paroles for DACAs, but it had to be an immediate relative. Really, it had to be a parent. I believe we had somebody who was trying to apply for a grandparent, and they did not approve it. They rejected it. So while the agency, when you mailed in the application, accepted grandparent as a close enough relative, the local field office interpreted the policy differently, and they would turn those away. So again, I would always caution, you know, if you are not using an immigration attorney or experienced immigration attorney, then just do as much research as possible. Again, that isn't going to get you kicked out. And also keep in mind, you can't just apply for a travel permit. You have to first be granted DACA. And so now, you know, for the person who sent us the question, the person has DACA work permit. So under the order, they are eligible for a travel permit for advanced parole. For those that don't, they first need to apply for DACA and be granted DACA, and then once they are granted DACA, then they can apply for travel permit. You know, we'll have to see what will happen. I watched the interview, most recent interview with President Trump, and he signaled that he is going to make an announcement on immigration again. I say again because there's been a few of those in the last, I don't know, 24 months. So we'll have to see what it will entail. He was referring in this one and previous statements that he'd made to Dreamers, that he's going to take care of Dreamers. So again, you know, there's been those statements before, not much traction happen afterwards. So we'll see, you know, what will happen. Yeah.
Yeah. One other thing about those applications for advanced parole, just because you meet some of the requirements doesn't mean that USCIS is going to grant you the advanced parole, and that's because it's discretionary, meaning it's even if you have the evidence or have the urgency, at the end it's immigration's call. Another consideration, and I think it's going to be interesting, assuming they give us the green light to file the applications for advanced parole, it would be how does COVID affect, how would COVID affect the application or the decision to grant. That's going to be interesting to watch and monitor, because as we know, there's been some restrictions upon re-entering the United States due to the pandemic. And so it might be something where immigration will weigh that carefully before they make a decision. But we have to wait and see what happens. And again, we're waiting for further information. We have a question here from Juan Pedraza. Hi, Juan. And he's asking about, will the 1040 Texas count as evidence? And I'm taking that this is in regards to the discussion we were having about physical presence, that one of the requirements for DACA is to show that you've been living here continuously in the United States from 2007 to the present, and they will count your taxes, anything pretty much that points you here in the United States and has your name, even traffic tickets. That's one of the other questions. Our clients will ask our questions. We'll ask our client about their ticket history, the criminal history. And sometimes they don't have any records or evidence to show that they've been here for a certain period of time. But if they have a ticket, if they got a ticket during that time, that ironically that counts as a piece of evidence. So that's interesting there.
You actually had a client for TPS who was in removal, who was detained, ready to be boarded on the plane, and we're fighting kind of two fights keeping him here. It was a local pastor. And at the same time, we had the application for temporary protected status for TPS. And it's funny that you mentioned it, Nick, because basically we won by getting the TPS approved because of a ticket, a traffic ticket that he got here in Texas. And so that was basically the final piece on which immigration wanted to deny us because we didn't, or they thought we didn't have the necessary evidence, but we did. And so the good, long story short, and good story, good outcome. He was released and he was granted TPS, and he is still here. So yeah.
Cool. We got another question. This one's not related to DACA, but it's related to the announcement that was made by the Trump administration. I'm from Germany and need to travel to the United States for the fall semester. I heard of the travel ban for citizens of the European Union. Will I be able to attend my classes next semester? Martin, we heard a lot lately about the student visas.
Yeah, so there was a basically it's kind of a whirlwind because you go to sleep, you wake up, and then there may be something else that was released, and there's just so many different policies and things are changing, and proclamations issued, and then exemptions being made to those proclamations. So one of the big deals was for international students, and that was a big deal a couple of weeks ago when they basically the schools tried to really protect the employees, the professors, and also the students from COVID, and so they were announcing that they were going to shift the curriculum online. And so your typically foreign students were able to, so let's just say they take a full load of 12 credits, and they were allowed to take one online course, and then everything else, the remaining credits, classes had to be taken in person. And so a lot of schools, including Harvard and MIT, were indicating that we will be transferring to online-only curriculum. And so the administration came back and said, okay, well, anybody who's going to have online-only curriculum will not be allowed to stay. They may be removed. They will not have the visas issued if they're not here. And so they backtracked. There was a lawsuit filed last week, and so the administration basically withdrew those that requirement. And so the students were able to attend classes. Now the question is about the travel ban, and that's for citizens of the Schengen zone, which is the European Union, the UK, and Ireland. So they were in that travel ban, and basically they lifted the requirements or the restrictions, basically they categorize them under the national interest exemption, NIE, and so if you let me see, does she have or does he have a visa? So basically, under the new announcement, but the Department of State, if you have a valid visa, you don't even need to apply for the national interest exemption. If you don't, then you basically apply for the visa and you should be granted it. And then basically with that, you just board the plane. I would recommend printing out that advisory from the Department of State, and it's you can just Google it. And just carry it so you can board the plane and you can easily clear the customs in the U.S. So lots of questions from foreign students. When first they were afraid of there was kind of like a twofold issue. Will I be even able to go and study? And then the secondly, due to the ban, will I be able to board the plane and come to the U.S.? So students, foreign students that hold F1 visas, they don't even need to apply for the NIE, for the exemption, national interest exemption. They will be allowed to enter the U.S.
And you mentioned the Trump proclamation, which again restricts certain certain entries into the United States. We know that some family visas have been restricted, with exception to those who are applying through a U.S. citizen or a minor child applying through a U.S. citizen. And there were also some recently, they expanded on those restrictions to include work visas, right, Martin, like H's and L's and J's.
Yeah, so we mentioned it last time. It's a presidential proclamation 10052, and basically it included H-1Bs, which is for specialty occupation workers, H-2Bs, which is temporary seasonal workers. Then there were some J-1s, which are exchange visitors, and then also intracompany transferees, and which is executives and managers, specialized knowledge workers. So basically, that proclamation stated that if you were outside of the U.S., and the proclamation went into force on June 24th, 2020. So if you were outside of the U.S., you did not hold one of those classification, one of these types of visas, and 3, you did not have some type of a travel permit, advanced parole that we mentioned earlier, that you would not be able to obtain your visa. And so again, for those that were in the U.S., had an L1 issued before, and we have plenty of clients that we're extending status. They get a new L1 or new H-1B because they were in the U.S. and they had a valid visa issued before. They'll be able to, and they need to travel outside and get the visa. They'll be able to travel out and obtain a new L1 visa, for example. So. Yeah, lots of moving pieces, and that's what's been a kind of a fun time for immigration attorneys. Many juggling balls in the air, and at any given time, any given moment, you don't know how many are in the air, and so it's that's what's been challenging for us.
You have to definitely stay on top of things, and speaking of staying on top of things, the things change frequently, and we learned recently last week that the consulate offices, those offices in the embassy that are processing interviews, are slowly but surely opening up, and the Department of State said that they're going to start processing these, going forth with these routine services, interviews, but it depends on. It's not going to be a global wide reopening. It will depend on what the circumstances are, what the situation is with COVID in the local country before we see any openings. Right now in Ciudad Juarez, things remain suspended. I haven't received any interviews as of late, but it's something that we're monitoring. The good part, or the good news, I should say, is that USCIS last month started to reopen, and we're seeing more oath ceremony notices, more interviews. Not as much as we would like, but we totally understand that this is a measure to stop the spread of COVID, as well as fingerprints, applications for residence naturalization, work permits. The applications that will require a person to submit their fingerprints, we're hopefully we'll see them reopening. Supposedly this month is when they were supposed to reopen those application support centers.
Yeah, and I also wanted to add, Nick, and people may have heard that there has been notices, furlough notices going from the USCIS to, I believe it was over 60% of the workforce, somewhere around 14,000 employees, which is a tremendous number. And if you can imagine, you know, if that really happens, because apparently the agency's facing about $1.2 billion shortcut, and they're asking for a government bailout, agency that is requiring all the applicants for adjustment to show how responsible they were and will be, so they will not become a public burden, public benefit, is somehow asking for a handout from the government. So a little irony there, I guess. And, you know, we'll see how that's going to play out. Another interesting news bit there is that there are maybe 50 or 60,000 work permits and green cards that are being held up because I guess the agency did not properly source the vendor for printing of these cards. So you have people that are receiving notices that their employment authorization is approved for 1 year or 2 years, depending on the classification, but they can't, they don't have the card, and same thing goes for the green card holders. I think both categories were in the 50, 60,000s, which is a quite a bit, and I don't think there was any kind of good justification, clarification of what will happen, you know, in the foreseeable future. So the furlough is supposed to begin August 2nd, which is 2 weeks away. And I don't know if they will get, and I just want to remind everybody that the USCIS is a self-funded agency that basically survives and pays salaries from the filing fees it receives. And so I guess with slowing down the immigration and the immigration applications and petitions, they're receiving less money, which means that they have less money, and now they are basically threatening the Congress that if they don't fund them, that they're going to have to furlough, let go, temporary layoff, you know, 60% of the workforce. So, you know, that's also going to play a role in the timeline. Not only were we slowed down, and the timelines were slowed down with COVID, with the coronavirus, and but also now we're looking at this potential shortfall in funding of the agency. So that's going to be fun, I guess.
Yeah, and you know, they're mentioning cutting services, and this is why we're all constantly monitoring. If not only could they cut services, but they could also look into cutting whole processes, things that we were used to. And there was some rumor about the provisional waivers, applicants who are here, they need to go to the Aguadas, for example, or go to their consular office to finalize their process, but they have to file a waiver here. There were some discussions about maybe possibly doing away with that. So this is something that we're monitoring on a daily basis. Speaking of the COVID impact, one of the common questions we receive because of COVID, we see more and more people who have to apply for and receive unemployment benefits, and we certainly have clients now that are waiting in line for their naturalization, but in the meanwhile, they were let go or they were laid off, and now they had to and they were applying for unemployment, and that's one of the concerns that they have. Receiving unemployment affect their applications for citizenship, and not only citizenship, but we're also talking about DACA, people who have DACA who were let go because of COVID. Will that affect their status? Will that affect their renewal? And the short answer to that is that it shouldn't. Unemployment is not considered a public benefit in the sense that the type of public benefit that would affect a person from obtaining an immigration benefit. Unemployment, you pay into that, and you're definitely are eligible, but you have to check the state requirements. Each state is different. Here in Texas, it's more broad in who is eligible for unemployment. But if you need to apply for unemployment, certainly you should do that if it means survival. So yeah, it's important to speak with your lawyer before. If you're unsure, it's very important that you speak to your lawyer just to make sure. So we're here at the closing segment here. Martin, is there any other thing you want to share with us?
No, just I would recommend and really just call on to people that are eligible for naturalization. If they have immigrated through employment and they've been residents for 5 years, or if they have been married and became a resident through marriage, or have been married for at least 3 years to a U.S. citizen, and otherwise meet all the requirements of citizenship, is to apply and perhaps you will not make a difference in this elections or these elections coming up, but definitely get in line to make a difference in the future. Under the prior administration, the elections were all about getting people engaged and having immigrants to take that first vote and to cast that first vote, and so it doesn't seem like that it's been a priority in this administration, and so some would even argue that there has been some slowdown, so not too many people could vote, and so if you are not for this for November, but for the future, make sure that you consult, that you meet the requirements, and then you go through the process, so we can have more eligible voters and have vote for the change that we need. And we'll just have to see what it's coming from the White House. If somehow the proposal will change the preferences of the president, I don't know. I mean, I doubt that any proposals that will be made will somehow be met with open arms from the other party, and some kind of a deal will be struck. But we'll just have to hope that he's done, or the administration is done with the proclamations, that nothing else is coming. Because as I said before, it has been a whirlwind just to watch it and follow it, and so hopefully nothing else is coming. Perhaps some of the travel bans will be eased, although that is connected closely to the COVID-19 situation. So hopefully nothing more serious, no more restrictions, just easing of your professionals, your H's, temporary and seasonal workers. Those are people that are really needed in this economy and the United States. And I'm an immigrant myself. Has been built on immigrants' backs and partly and also by immigrants. And so it constantly needs the infusion of new ideas and new energy, and so that's my wish for the next 90 or 100 days, so we don't get slapped with anything more restrictive or more restrictions.
Yeah, it's crazy. And to summarize, this whole DACA development, the Supreme Court giving an opportunity for many applicants to file their DACA for the first time. And last week we saw a court decision from a federal court in Maryland, which basically gives the green light to file. At least it tells the government that they should accept these applications instead of rejecting them as they were doing. gives us some confidence moving forward. I will warn that there is a slight risk that immigration might hold on to these and not process them because there's no guidelines right now. But at the very least, you should be looking, if you're eligible to file for DACA for the first time, you should be looking at least preparing your packet. And one thing that is going to involve a lot of time, or could involve a lot of time, is gathering those documents to show that you've been here in the United States since 2007 to the present time. We will be updating you via Facebook. We have a YouTube channel as well, Twitter. We will be sending you updates, but you could also get updates on our application, right? Law Pilot, Guardian, and I do have the information here, where you could text Guardian to 555-8888. You will get an alert on your phone when there is an important update. And as Martin is showing, right, it's an emergency button that you can press in case you are in a run-in with the police or ICE. You can press it, and a loved one will receive. A loved one being a lawyer, including a lawyer, we can be loved as well. We will receive the alert showing where you're at on the GPS map, and we will get some information as to what's going on. And so that way we can react as quickly as possible to try to resolve the situation, or at least get in contact with your family as well. Well, thank you for joining us, and feel free to leave comments or questions. And if you have any, if you would rather consult in private, please give us a call. And you could also book a consultation online. Are consultations right now for DACA free at this point, Martin? I never know. I don't. Well, it looks like
yes. We are. Everything is well, I mean, except the business base. Yeah, patients, the DACA, your family, immigration, those are still complimentary.
Okay. Well, take care, wear your masks, and we're here to help. Thank you.